Thank you so much, Architect Uri. Also, I'd like to thank everybody for having us here today and thank Pam Northern Chapter also taking the time to come out on a Saturday morning, even those on Zoom. I think. Sorry. Why does it work? Okay, so we'll start first with ARcover. What's it about? I mean, today here we all talk about professional indemnity. And this is the areas that I'll be starting off today with. So we'll start with birth of ARcover, how it came about. Introduction on what it covers, what are the special terms. Of course, why is professional indemnity important? And everyone will tell you what is covered. We also tell you what is not covered, so you're clear. And when and what do you notify? So I'll just go in straight to it. So ARcover really, we started off, I think, with when we got in touch with Lembaga was saying, how do I protect the members? And because of legislation and things like that, then we were introduced to PAM because, right now it's not mandatory or compulsory for architects. So we then worked together with PAM and put something together. I think they can't see that. Okay, is that better? Yeah. So how it came about. So the main thing is, how do they want to? Pam's worry was, how do I protect the profession? PI, I think most of the architects that I speak to nowadays tell me, oh, I want to buy single project. Oh, I want to buy annual PI. It's complicated. They tell me they don't understand the difference. So it's things like that. What should architects do? And then question, are all my past projects covered? And then, sorry, am I too loud? Oh, okay. And then the limits that are offered are quite low. What should we do? Oh, I'm very scared. What if I retire and someone takes an action against me? Am I protected? And when I have a notification, usually what the feedback we used to get was, I'm allowed to just go and do things on my own, and then I don't know what to do when there's a claim, when there's a suit on my door. So what happened was, when we worked together with Pam, it was really to put something together which is for the architects in Malaysia, for the profession. And that's where ARcover came about. So I think, as Architect we introduced this now, and Madeline, so we are from Lockton. We are consultants to the insurer, who is Pacific and Orient, and also to PAM. And this is, ARcover is a scheme that was arranged for architects in collaboration with PAM and the insurers, and it was launched in 2022. P&O is the insurer, Pacific and Orient Insurance Company. Yeah. And I'll go through the terms in a bit. Also, just one more note. I think architects, most of the time, you are lead consultants on projects. And I know you deal with sometimes landscape architects, IDs, who also need cover. So I think this is one of the enhancements that we're working towards. So if you have any of these other consultants that need assistance on PI, do let us know. We can actually put something together for them as well. But ARcover is, as the name goes, AR, it's for architects. Just quickly, on your seats, I think there's already the brochures. The premium guide, just to run this quickly through with you when you have a look at it. On the left, how you look at, this is a rough guide, yeah, of your premiums. So let's just say how you look at it is, if your annual revenue is roughly around $1 million a year, for example, that's where you look at the first column, you look at 1 million. And then the next column looks at what limits you want to buy. So if you're looking at $1 million, then you go to 1 million in the next row, and you will see that the premium is roughly 4,070. Again, this is a guide. It all depends. It can be higher, lower, depending on what is your actual revenue. But this is just to give you a rough idea of how, what you're looking at. And this is an annual premium. So, I mean, if you have questions afterwards, you can always ask me, but I just thought I'll just run to explain the guide first. Okay, so professional indemnity. Why do you have it? Why do you need it? Right? It's really to protect you, not just you, your firm, your employees, against any allegations of professional negligence. So anything that you do in the course of you providing service to your clients or to any third, I mean, it's your professional service to any third party, and there's an allegation of negligence, this is what professional indemnity insurance is there to protect you. And what happens if there is a claim? It's usually when, if it could be a civil suit, and then there's an award judgment and you're legally liable to pay that. Second key, as I mentioned earlier, what you're covered for, as long as it's in the conduct of your professional service as an architect, that is what your professional indemnity is for. I mean, it can't be if you're an architect and then you're advising on something totally unrelated. I don't know, I can't think of something on the top of my head, but it has to be something that you're supposed to be doing as an architect. And you have the third one is, it is as long as it is notified during the policy period. I'll explain to you later why that's very important in terms of what claims made is. Who is covered? Then the firm is covered. All the professionals in the firm, all employees, your graduate architects, principal architects, signing architects, employees, your staff, everybody is covered as long as they are an employee of the firm. So if the insured practice is Architect Ui's firm, Architect SM Ui, everybody in Architect SM Ui will be covered. And what does the policy pay? Why do you need it? What does it pay out on? It's basically any awards, damages, even if there's a settlement, if it's decided that the matter is settled, the settlement sum is then covered. And of course, legal fees. Okay, yes. Legal fees. And legal fees, it could be for two things. It could be when there's a legal suit, when it goes to court, or also it covers the regulatory inquiries, and you need a lawyer to advise you, that cost is also covered. So these are the key payment. So what is the benefit of this? Really, buying PI is good risk management. You don't have to worry. You avoid, if there's a payout, you've got a policy to protect you. Helps reduce stress. You've got lawyers, you've got consultants all to assist you in the event of a claim. Gives you peace of mind. Focuses on practice. One more thing I didn't want to put up there, but when I think most of the time architects call me and say, I need to buy because I got a project. I don't know whether I'm going to get a project, but I just need to show it for a tender. Then I always tell them, that's not how it is. You need to maintain a PI policy. It just basically it gives your clients confidence in the firm. It's, it helps in certain ways, right? So I just thought I'll put it out there. Now, what is covered? I tried to make this diagrammatic because feedback was architects like pictures. So I don't know whether it makes sense, but I'll try and explain it. So the first thing, the main thing that you must always look at when you buy any PI is your retroactive cover. What is retroactive cover? Basically, ours is unlimited. So it covers you for any projects from the date of incorporation of your company, whether it's completed, not completed, whatever, ongoing, everything is covered from inception or incorporation of your company, right? So, but of course, if you already know that there is a claim or a circumstance, you already know there's a problem, that prior to purchasing the policy, that is not covered. It's like you see smoke and then you go buy fire policy, cannot lah. You have diabetes, you buy your medical, they will exclude diabetic, So same thing. If you already know of a problem, of a claim that is already in existence, that particular claim will not be covered if you buy it, if it's before the inception. So what it means is this: incorporation, then you buy ARcover now, right? So it covers you for all your past projects, provided the claim comes in during your policy period, because this is a claims-made policy. So it doesn't matter when the work was done. As long as when the claim comes in, you have an active policy in place, that's the policy that will be triggered to cover the matter. Is my diagram clearer? No? No. Okay. So, and this basically actually goes across the projects can continue, right? So most important that you need to know is, as long as you have a policy in place, You notify it during the policy period. The moment you're aware of a claim, it will be covered under ARcover because it covers everything from incorporation. Just, yeah, it's an annual policy. You can't have a gap, right? So yeah. And yeah, that's, any questions on unlimited retro cover? Or I can move on. Okay. Next. This was one of the main things that Pam said is a must. I can tell you right now, as of today, you can't get any other PI policy out there for architects that offers you lifetime retirement cover. What it simply means is there's two parts to this. So you've got the architect and you've got the firm. So generally, if you retire and the firm is still in existence, you will be covered under the firm's policy as a past principal or past practitioner of the firm. What happens when the firm is not there to protect you, right? That's the problem. So once the firm shuts down, that's when the lifetime retirement cover kicks in for the individuals. But this is provided you are permanently retired. It cannot be, I move from one firm, I'm part-timing, I still consult on architecture work. No, it has to be permanent. I mean, full retirement, not permanent, full retirement from architectural practice, right? So example, firm, Architect Chong's firm lah. Okay, so Architect Chong's firm buys the policy now. In 2025, Architect Chong retires. Firm still around. Claim comes in, no problem. Firm's policy covers. Say 2027, the firm shuts down, but a claim comes in 2030, right? And it's against Architect Chong. Architect Chong will be provided cover under the lifetime retirement cover. The limit that is applicable will be the limit that the firm purchased in the year of Architect Chong's retirement in 2025. So if in 2025, the firm bought 5 million, that will be the limit that will protect Architect Chong throughout his retirement. It's not at no additional premium, but it doesn't mean every year you get 5 million in your retirement. It's 5 million aggregate throughout your retirement. So that's how it works. Any questions on that? Yes. No, it isn't. So there's no additional premium. Yeah. Yeah. Well, yes, he can. But the firm also has to be shut. So if you're a sole proprietor, sole prop, right? You buy, okay, I mean, we shouldn't do this, but it's, for example, if you were to buy it next year, you buy 20 million, then the following year you shut your practice and you retire, that 20 million is supposed to be covering you for the rest of your life. The firm has to pay, yes. Because if the firm is still around, then you're covered as a past practitioner, previous employee, previous principal of the firm. So the firm's policy still provides you cover. Yeah.
Can I ask a question regarding the premium guide? Or that later we
Then
can
maybe
talk.
I think that one we can do because we have a Q&A as well. Because is it?
Okay.
Because you're talking about the pricing, right?
Yeah, I don't know how it applies. I mean,
it's okay. Maybe I can come and explain to you how we look at the categories.
no problem.
Yeah.
Okay.
Any other questions so far?
What if the firms provide more than architectural services, including engineering or whatever other green consultation?
As long as it's declared when the firm purchases, because when you want to purchase the policy, you will be asked to fill up a proposal form. In the proposal form, you will have to declare all the work that you do. Two things. As long as you declare it, and as long as an architect is allowed to do it, then it's covered. It's legal. Your Architects Act allows you to practice in whichever area. Insurers will not be there to police you and say, oh, you illegal or legal, but you should know lah. It's under your Architects Act, right? So as long as it's declared to insurers that this is what you do, this is a breakdown of the work that you do, the proposal form has all the details you can select. And they will usually ask you how many percent, town planning, how many percent engineering, how many percent consultancy that you do. Then based on that, that's how insurers decide your premiums. So as long as you declare it and as long as it's allowed by under the Architects Act and your regulators, then it is covered.
I think this question probably is relevant to many of us. I think most of us, I think and hope that has bought their own what they call insurance cover, indemnity cover. So how does that mean that, let's say, in my insurance, I have to wait for my insurance cover to expire, say June, and then after that, this ARcover comes in, and is there guarantee that there's going to be a similar sort of coverage?
Okay. First thing, maybe I'll just explain. When you have two policies in place, it doesn't work as a top-up. Huh? So either one only can apply. So normally what I tell architects, if you know your policy is expiring, say, 1st of September, you please, and you want to change, you please come to us now so we can get the policy in place. So if it expires 1st September, I'll get you your ARcover in so there's no gap. There's no gap. You have to make sure that there's no gap. The problem always happens when if there's a gap, and then remember I said just now it's a claims-made policy. If your luck, touch wood, is not good, and then it's in that gap is when the awareness of a claim. I mean, it's happened before. It's really quite, sad. But so that's why you just make sure if you know it's expiring, give us a call so that we will just give you a quote before that. You got time to decide. If it's a month in advance, it's fine. If it's 2 months in advance also, it's fine. Got firms ask me for quote for next year already. So it's fine. It's just for you to understand so that once you're ready, you already know, okay, this is roughly what I'm looking at, and you can get the policy.
If you're in a position where you've just renewed your PI, check with your agent or your insurer. I'm not encouraging you to switch, but sometimes quite a lot of policies allow you to actually, what's the word? Return it. You can return it because they do refund it. Yes, they do give you, they will charge like an additional 50 ringgit administration. So that's why I said, please don't take it as I'm encouraging you to leave yours, but those options are usually there with your agent or your current provider.
Yeah, is it is it subject to adjustment?
Yes, it is a guide. If you look, there's some first at the bottom, there's some subjectivities there. And if you can see the revenue, right, it's like 1 million, 2 million, 500,000.
I know.
So it depends on where because usually insurers will ask you average of 3 years revenue.
Okay.
And then they also need to look at the type of work that you do, how many employees you have. Basically, the more work you have, the higher the risk. Insurers need to weigh the type of work. So the premiums, but you can know, so basically if your revenue is between 1 to 2 million, roughly you look at the bottom half and the top half lah. You should be within that region.
No, I mean that chronologically speaking, let's say the premium is adjusted in the future, or is this fixed?
Okay.
I mean, we got to know, right?
Right now, when you fill up the proposal form, if your work is basic architectural practice, That is the guide that's applicable. But at the bottom, there are subjectivities for those who do aviation, maritime, bridges, warehousing. Yeah. So if you fall in these high risk areas, there is usually a 10 to 15% adjustment. Okay. So it depends. But if this firm is 100% aviation practice, then it cannot be a 10 to 15% adjustment. It will be higher. I cannot tell you how much higher. That's the first part. The second part of your question, to answer your question, is whether the premium increases year to year. Now, for the past 2 years, it hasn't. There is no reason for insurers to increase it at present. That's the best answer I can give you. I cannot guarantee you that it will not go up, sir. But it might. Yeah, it might in a couple of years. But for now, it has not gone up in 2 years. Yes. Okay.
The next thing that's covered, this is another one that is not covered by other policies. It's unique to ARcover from what I've seen so far. Basically, your professional indemnity is for civil suits, civil liability, where it's compensatory damages, you have awards. So that is covered. All the defense costs, all, as I mentioned earlier, the lawyer's fee and everything in a civil suit is covered. In addition, ARcover gives you criminal prosecution costs. I mean, in a criminal proceeding, of course, there is no monetary award, but you still need a lawyer to defend you. So the cost of the lawyer to defend you in criminal proceedings is also covered. So it's criminal proceedings, civil suits, regulatory inquiries. I don't know if Lembaga calls you in for any disciplinary proceeding that you need someone to advise you or even attend the proceedings, you have lawyers to assist you. The cost of the lawyer will be covered all within the limit that you purchase. Yes.
The lawyers, are they being chosen from your panel of lawyers, or can we recommend our own lawyers?
It's our panel lawyer, and because you're in Penang, that's where we have that really later. That
Yeah, of
is
course. I
making-
mean, it's one of no doubt.
I think, how do I say, for the premiums that you pay, you get someone like Dato' Murali to defend you. I think no one, yeah.
He's only one person. What if he's too busy? Then
Because panel lawyers more or less agreed to a reasonable fee scale with the insurer, shall I put it? So if a lot of money is expended on legal costs, let's say you choose your own lawyer, you choose your own, and everybody's got different fee scales, everybody charges differently. The insurer will pay, but at the end of the day, as a group, there's too much money spent on defense costs. So the following year, the premiums may go up. You see? So that's why managing the whole scheme, every aspect is important. Does that also make sense to you? Yeah. Well, if there is a situation, the insurers will consider it, but if Dato' Murali is the most appropriate lawyer to handle it, then their choice, because they are paying, yeah? Yeah.
Okay, so the next thing that's covered, loss of documents. I thought it was quite good, right? Explains what I'm trying to say. So loss of documents basically means it's not something where it's not like your office policy. Let's just say there's a flooding and then everything gets wiped out. Then you call me and say, Shamli, I want to claim under ARcover to reconstruct all these documents. No, it doesn't work that way. How loss of documents works is it's almost like a mitigating so that to avoid a claim. So you already know there's a project due next week. You've been working on this project for the last, I don't know, 6 months, but suddenly your computer, something happened, it crashed, and you now need to reconstruct all these drawings that you've been working on for the last 6 months. So what happens is you need, as the picture shows, you need additional resource, people working overtime. So the cost of that to reconstruct documents for the project that you need to submit next week, so that if you don't, you're going to get a claim, right? So insurance, okay, you can call me, they will pay for the cost of reconstructing this particular project. It's something that it's going to happen. They don't want you to, it's to avoid a claim. They know you didn't mean to lose the documents, but it has happened. So now you need to meet the client's deadlines and requirements. So the additional staff that you need, the additional whatever resource that you need to reconstruct these particular documents for this particular project that is due, that's where your loss of documents comes in. So it also includes electronic records, but this is not a cyber policy. Yeah? So please don't call me because my computer got hacked. I got ransom requests. No, that's a different policy. This is purely to help you reconstruct something when it's lost and you are due to provide it to your client. So that's why I got a claim.
And the computers are sort of stolen or hard disk storage are stolen.
Yeah. In the event of that, but as I mentioned earlier, it will not cover all the things that, yeah, it's something which is urgent. I mean, if it's a project that you can still work on next 2-3 years, you have to, I mean, that one, you just continue working on it, lah, you know, but it's something where tomorrow the client call me, the client's going to jump down and come down and tell me, excuse me, you have to get this delivered. That's when this cost comes in.
So what is sub-limit, the one in blueprint?
So because the sub-limit for this is 10% of your policy limit. So it depends on what you buy. So it applies. It's like you cannot get 20 million cover for loss of documents. Lah. Yeah. Next is, it also covers for any allegations or any claims that come out of dishonest or fraudulent conduct allegations. But it only covers the innocent party or employee. So if you are the perpetrator who lied to your client and then you get sued for that, you know, you told them, I'm going to put 2 boulders in there, then you're going to put 1, and then you knowingly do it and you get sued, and it transpires that you were the party who was fraudulent and trying to cut corners, you will not be covered. However, if your partner has no idea that you did this on your own and then your partner gets dragged in, your partner will get covered as the innocent party. Of course, you know, insurance will ask how much. I mean, when lawyers defend you, it will come out, right? How much you knew, how much your partner knew, it all will be established. But if as long as it's provided that you are innocent, the partner and employee is innocent, and they were not aiding and abetting this dishonest and fraudulent conduct, then they will get covered.
High Court judgment saying that you're innocent, then because innocent is a big and grey word.
Yeah, basically, facts of the case and the evidence, at the end of the day, it's the insurance. If the insurer finds that that partner is innocent, then they'll continue cover. But there's a caveat to that. In the event it becomes apparent later that that person was also dishonest, then they may choose cover. For example, sometimes when they go to court, they have covered all along. But if the judge finds, as a matter of fact, that that partner is also dishonest, then they may take a different view. At the end of the day, yes, at the end of the final judgment, right? So it's very factual, it's fact sensitive. I don't think anyone can say one size fits all. It really depends on the facts of the case and how much the partner knew or did not know. And all that will become apparent as the case proceeds, especially when you go to high court, when you go to a court and the evidence is presented. So if a person is honest, he will know he'll be covered all the way. If he's got something to hide, something comes up later, he knows that there's a risk of not being covered.
I mean, there are cases that when, I mean, our lawyers, let's say, that comes along with us and feel that we are honest, and we go and sort of fight in the court, but the judge says that we are dishonest. So based on whose judgment do your insurance make that decision?
Based on the judgment.
That's fine. what the judge says is what matters. Because we lawyers or any professionals can come to our own conclusion and say whatever it is. But judgments are made based on evidence in the trial. So what the judge says, if I may use the word, is gospel. It's not relative.
Yeah.
It's not relative because in this country and most civil law jurisdictions, we go by what the court says. It is not relative. What the court says is gospel. That's how our legal system works.
Yeah. Anyone else questions? No. Okay. And the next point, remember earlier I spoke about individual when you retire and then you get cover under your firm, right? So for the firm, let's just say in a situation where the firm decides they need to shut down and you want to make sure that in the event you want to protect all the work from that comes out of the firm. When the firm wants to shut down, you can buy extended cover up to 6 years. But this, for the firm, it's at the additional premium. It's not like a lifetime retirement cover that she's free. So for example, it actually, if you're a sole proprietorship, usually this doesn't apply because it's you and just you and your firm. But if you come from a bigger firm and you are a private incorporated company, you've got several partners, and you just want to make sure that everyone's decided to go their own way. You've gone to you're either going to another practice or you are thinking of moving to a consultancy. But as a group, you're worried, what if our firm gets a claim for what they've done prior to them shutting down? You can choose to buy extended cover where you are allowed to notify a claim for up to 6 years. So depending, if you want to buy it for 2 years, insurance will quote you a premium up to maximum 6 years. Why 6 years? Limitation. That one later Dr. Murali will expand on during his session.
Lifetime retirement covers, does it cover only the principals or partners, staff, employees?
It covers principal, partners, everybody, employees too. But you see, the reason why I generally don't talk about employees is because because it's retirement, most of the time employees move firms to firms. Just because they move from one firm to the other and then they retire in the other firm, they don't get cover under your firm. So mostly it's really for the signing architects because you are the ones who will be, the chances of an employee or staff getting an action against them 30 years down the line is very slim. What will happen? They can't find the firm. If there's a problem 10 years later, they can't find the firm. Who are they going to go for? The signing architect. So that's why it's more important but in answer to your question, yes, the rest are covered too. Yeah. So now all that just now was what is covered. Quickly, what is not covered, as I mentioned, if you already knew of a problem, then you come in, like a client has come to you and said, I'm not happy, I'm angry, I'm going to sue you. And then you're like, alamak, they're going to sue me. Quickly call, buy policy. And then, policy kicks in. Next thing, legal suit comes in. Sorry lah, you already knew about it prior to purchase of policy. Second, pro bono work. Anything you do for free and you don't receive a fee, it's not covered. Yeah, yes. Can. Well, yeah. It's generally the idea is it's for your services where you've been commercial services that you've provided for a fee. So all pro bono work is not covered. Next, regulatory fines and penalties. Remember earlier we mentioned if you get called for disciplinary inquiries and all that, and then you're slapped with a fine. The cost of the lawyer is covered, but the fine itself is not covered. The penalty itself is not covered. The monetary. Sometimes, I don't know, I think they're not happy with the way you practice and then they suspend you for 3 months and say you pay 500 ringgit as a slap on the wrist. That 500 ringgit is not covered, but the cost of the lawyer is covered. So that's what is not covered. Commercial risks, of course, that's not covered. Your trading debts, your rental, EPF to your client, to your employees, all these things are not covered because it goes back to what I said at the start. It covers you for any claims that comes out of what you provide as a professional, your professional services as an architect. Employee disputes, if your employee takes you to court, wrongful termination, all these things not covered. And as I mentioned, ransomware, cyber policy, this is not that. Anyone hacks into your computers, all that's not covered. So that's a lot of items. So next, we keep on talking about actually when and what do you notify? So I keep on saying, right, if you know a claim, you know a circumstance is not covered. So what is a circumstance and what is a claim? So under the policy, a circumstance is the moment you are aware. So it always goes back. The key thing is your awareness. So a circumstance is when you are aware of any problem, any fact, any issue that you think might result in a claim. So like potential claim lah, basically, right? And what is a claim? A claim, as long as it's a written or verbal demand, letter of demand from a lawyer, or legal proceedings for any lawsuit that lands on your table, hence you've been served, that is a claim. So the difference, yeah? So the moment you are aware of either a claim or a circumstance, that's when you need to notify. Okay, I give a scenario. This is what, actually this was a real life example. A very recent example. So an architect spoke to me and said, hey, no, I will only make a claim when payment is towards any judgment only. Everything, I defend myself already. I now have a judgment. That is only when a claim, that's the definition of a claim. Only when there's a payment, then only I make a claim. What? Because that's not how it works, as I mentioned earlier. So please, awareness, this is wrong. Okay. Yeah.
Realize something, yes. So that happens to be a misconception that the claim is when the court says you have to pay an X amount. So that's a real misconception. And second is, do not attempt to increase your professional indemnity, whichever provider you're with, once you have a claim, because it's pointless. When the judgment comes out, they will know when you knew about it. So your original limit will apply, not the increased limit.
So I mean, maybe I can just elaborate. When we were having this discussion with the architect kept telling me, it's a frivolous claim. I don't have to claim because there's no claim. As far as I'm concerned, I'm innocent, it's frivolous. So therefore, I don't have to notify. Only if the court decides it is not frivolous and there's a payment, that's when I make a claim. So that's not the right concept. Because you never know, right? You need to, there's prejudice to insurers. If you wait till the end, maybe the lawyer you got, you were not correctly advised. Then when the insurers look at it, it's too late. They can't help you. You've prejudiced their position. So you can't expect insurers to pay at that stage. Hence why you have to notify it as the moment you are aware of a claim or a circumstance, sorry.
2 questions on fee, but I think we can do it during the Q&A. I hope the participants online can hear. The fee questions we'll respond to at the Q&A time.
So when do I notify? I think I explained earlier. So circumstance, the moment you're aware of a claim, a potential problem, notify. Don't wait. Don't worry. Are your insurance going to increase my premium next year? All that is secondary. Do not, just notify. That's why you have your professional indemnity policy. How do you notify? The moment you get a policy, we will send you an email. The policy at the start will tell you these are the contact details of the people, the claims team in Pacific and Orient, the insurer. Just write in, email them. You don't have to. I mean, you don't have to copy Pam. I don't think you want to copy Pam, but notify the insurers. The moment you find out, notify insurers. And then what do you need to provide? This is very important. Once you notify, you need to provide documents to support. Give an explanation. Usually once you write in and tell insurers, look, I have a potential problem, they will then guide you as to what you need to provide, the chronology of events. And then ultimately what happens, of course, then that's when the panel lawyers will be appointed to assist you. Then there will be further documents that the panel lawyer will then discuss with you to help you resolve the matter. It could be resolved, it could be defend you, it could be advise you in the background, it could be all sorts of things, which is precisely why you buy professional indemnity policy. So that's, oops, sorry. I have some top 5, sorry, there was 5 and then because I removed the 5th. These are the common questions that I get. First question is, must my firm and I be registered with LAM to buy an ARcover policy? The answer is not necessary. Because I know some of you have sole proprietorships and then you've got Sendirian Berhads. So long as the architect and the principals of the Sendirian Berhad are all registered architects with Lembaga, then fine. But because at the end of the day, insurance position is this. You must be doing something that they will only cover you for something that you're allowed to do. If you're breaching any regulatory requirements or any statutory acts, your Architects Act mainly, then you can buy. But if a claim comes in and it turns out that you've breached this, you've been doing something illegal, then your entire policy doesn't protect you. So it becomes of no use, right? So just make sure that as long as you're properly registered, you're allowed to do whatever you're doing, then you're covered. Next question is, I think this would answer earlier questions as well. I have 2 businesses. One do 100% architectural, another one does 100% ID. Can I get both covered? Yes, you can, provided when you fill up the proposal form, you declare both. You just give me give insurance the full information on both. So when the policy comes out, both firms will be insured, the named insured. So if you buy 1 million, the 1 million will cover both firms, as opposed to 1 million each. Yeah. Who should I name in the proposal form? You can name, because a lot of architects say, hey, my name. I say, you can name yourself, you can name your sole proprietorship, you can name whoever, as long as you declare the information. When you name yourself, you name your sole proprietorship, the income revenue is based on whoever you declare. So at the end of the day, that the parties that you name in the proposal form will be the insureds. I think the main one is usually when you're a sole proprietor. They always want their name and the sole proprietorship to be in the policy, which is fine. Sendirian Berhads doesn't really apply because you want to cover the rest of the principles as well. Do you offer single project PI? Yes. You can get single project PI. Common question, roughly how much? I can't tell because single project PI is very subjective. Depends on what is the project. And it is dependent on the period in which you are buying for, the extensions that you need, what stage of the project when you're looking for. And one of the things that I think in recent times I noticed for architects, the problem is, as the lead consultant, I think JKR mainly says, as the lead consultant, you need to make sure your sub-consultants have PI. And I get calls from like various, suddenly I get landscape architect, town planner, how I need to get PI, if not my lead architect cannot get cover. My advice in this kind of situation is always, as the lead architect, you get everyone together, buy one single project PI, cover this particular project and name all the consultants in this policy. As opposed to all of you buying individual single project PIs. Why? You have one policy, covers everybody, no problems. Submit that. So that's all I have. And any other questions? Maybe we'll take it at the end after that already. Thank you.
Ishamini. Good morning, everyone. So I'm just here to actually speak about certain basic stuff, not going too much into detail, not going to be very technical. A lot of you here may already know what I'm going to talk about, may come across as dry to you. Those of you who have not come across these topics may also find it dry because it's law, right? So please bear with me for a while. Right, it's well, the title is Panel Lawyer's Perspective as far as architects' duties and the law, basic law applicable or surrounding architects' duties and the work that we carry out. Well, let's start with architects' duties first. You will find your duties either defined or contained in various areas. The first one being in your contracts. So when you sign a contract, when someone appoints you, you sign a contract. For example, if an architect is engaged to only design a building, the duty to client is for that design only. If an architect is engaged as a contract administrator, I'm sure all of you are very familiar with this. Such an architect is then responsible for the construct phase up to the completion of the project, which includes CPC, CCC, sometimes contract management as well, where you will have to issue certificates, you will have to deal with your EOT. And of course, a lot of disputes arise out of EOTs. Parties applying will look for EOT. Your employer will not, of course, be happy if you keep granting EOT. So all those things will be defined in the contract. Yeah, as to whether EOT ought to be granted, is very factual, but sometimes there are certain laws that may be applicable to EOT, including certificates. Right? And of course, if you breach a contractual duty to the contracting party, which is the employer, then it may give rise to a breach of duty, basically, which is a breach of contract. Your liability in tort, of course, you owe a duty to your client. You may also owe a duty to various parties. When it comes to tort, for example, like negligence, is not limited to your employer only. Common law duties may arise, legal duties will arise, and it's to a wide range of people, even to your subcontractors, other consultants, and of course your client who's an employer. And this goes to an area which is not very straightforward. If there's sufficient proximity between you and the person that is complaining, then it gives rise to a duty of care. And that's Hadley, Bird and Heller is very old, still applicable. And the existence of the duty of care and the scope of that duty, of course, depends on the facts of each case. There is no one size fits all. And of course, there's another duty which is not a very easy one. And of course, architects and other professionals may not like it, which is a non-delegable duty of care. I will come to that, but just very briefly to mention now, duty of care, when we talk about duty of care, it is your duty of care. When you have an independent contractor, of course, you will say, I'm not liable anymore because he's the one who's doing the work. He's a contractor. He came to construct this. Therefore, I'm not going to be liable. But an exception to that is the non-delegable duty of care, which we'll cover later by looking at a specific case study. So, like all other professions, the standard of care to be observed by an architect in tort is that of an ordinary skilled person exercising and professing to have that special skill. So as an architect, of course, you have your general skill as an architect. But when you claim or when you represent that you have a specialized knowledge, because that duty of care will be higher to a normal compared to a normal duty of care. For example, aviation, now maritime, LRT, those who do that type of work, of course, possess certain other specialized skills. So that duty of care then will be higher. You can't say, I'm just an architect. I was advised on some aviation industry, whatever, or even runway. You know, I did what I could. But you actually held yourself out as an expert in runways, for example. Therefore, the duty of care will be higher. I think that's quite reasonable to expect. Apart from duty and liability in tort, you also have duty in statutes. Because there are various statutes that I'm sure all of you are familiar with this. Town and Country Planning Act, Street Drainage and Building Uniform Bylaws, even factories and machineries, DOSH, Occupational Safety and Health. And of course, you have your Architects Act, which regulates how you register and you conduct yourself and architect rules. There may be other bylaws. Because certain states, certain local authorities may have their own bylaws that may apply to architects practicing in that state. When it comes to submitting architect, whether it's the submitting person is an architect or an engineer who signs off that submission, all that will be regulated by statute. When I say statute, it's by law or regulations as well. So those areas are where you will find what your duties are. Now, that is as far as duties are concerned. I just want to go through commission inquiries as well, because that was mentioned in part of your coverage. In Penang, I'm sure all of you know, in the past 8 to 10 years, there have been 3 commissions of inquiries. Commissions of inquiries are like royal commission of inquiries, except in states where there are no royalties, or if it's not actually initiated by the king, then it's a commission of inquiry. It's the same. The force of law or the regulation or the rules surrounding commission of inquiry is the same as the royal commission of inquiry. So in Penang, as I said, there have been 3. One is where there was a collapse of that structure right on top of the UMNO building in McAllister Road, killing 2 people. And that was really aesthetics. The other one was, it was held together, but the other one was a collapse of the overpass of the new bridge before it was completed. And not so long ago, a couple of years ago, the slope failure of the landslide in Granite Road. So when a commission of inquiry is set up, it has got a force of law, it has force of law, and the panel of the commission of inquiry has wide powers. Their powers are similar to a judge in a court of law. They have powers to subpoena witnesses, they have powers to subpoena experts and various other people to come and give evidence and to assist the commission of inquiry. So sometimes, like in all these 3 projects, all these 3 commission of inquiries, I was involved in all 3 of them. Some architects, although mainly it was engineers, their design or their work and services provided was called in question. So those architects came with their lawyers, rightly so. The commission of inquiry's findings or recommendations has got no immediate legal effect on the persons responsible, engineers, architects, and well. It has got no binding effect. That means they can't issue an order saying that this architect must pay so much, or this architect is, but they can make a finding to say that this architect or engineer was negligent. It was a fault of this architect or engineer. But it doesn't stop there. So if a finding of facts under the law or otherwise is made, that may give rise to various other consequences like legal suits, criminal prosecution. I think the engineer involved, not architect this time, the UMNO building was also hauled up in criminal court because of the fault in his design or calculation and so on. Same in Granite Road. So it doesn't stop there. And when you are called, you can be called either as a party that may be implicated in that particular project or building or event, or you may be called to assist as an expert. If you're called to assist as an expert, of course, you don't need a lawyer, right? You're called because of your independent view and your expertise is needed to assist the commission inquiry. But if you're called because you may be implicated or you were involved in that project or building, then you must appoint a lawyer because the outcome is going to be very, very important. And that's why I think somebody mentioned that that is also covered. I think I won't go into the policy because that's not my area, but that's also covered as far as your legal cost is concerned. And that may drag on. The commission inquiries are quite tedious because a lot of technical issues, a lot of expertise are called and all that. So you are not going to just go there and give evidence one day and come back. It may just drag on. You may be recalled. There were, in all these things, there were various site visits and so on. So it's important that if you think you are called because you are implicated, doesn't mean that you're wrong, implicated, you should then go with a lawyer. Right? So that's as far as what I want to say about commissioner inquiries. Okay, now just to quickly touch on defense, what is important, how to prepare when there is a claim. This was also mentioned earlier, the first part, prompt notification upon awareness of a potential claim. So when there is a potential claim or a claim, don't worry about what's going to happen next. Just inform your insurers first to get the cover. What happens next is a different issue. Because if you delay it and if they decline, then you've really got a big problem. I mean, all professionals. So even if you think, yeah, that letter does not sound threatening, but I think I'm not comfortable with it. They may be hinting there's something wrong with what I did, then you inform. If not comes out of it, you've got nothing to lose. It's not going to affect your premium, I'm sure. So better to be safe than sorry. Right? So immediate notification, especially if you get a notice of demand. I mean, I don't think there's going to be anything ambiguous about that. You just send a copy and just inform your insurers. The other thing that is required, which I think part of what we were talking about earlier, which is dishonesty and so on, you must make a full and frank disclosure first to, I think, your consultants or your insurers and to the lawyer that has been appointed. You must, because if you do not cooperate, I'm sure there'll be a clause somewhere, a fine print in all our insurance policies, whether it's a motor insurance or whatever it is, that if you don't cooperate, they will decline. The insurers will decline. So, I mean, I'm not going to make comments about insurance, but right? We all have insurance. We also have professional indemnity. So if you make full and frank disclosure, give them everything, then there is no room for them to come back and say, but you did not give us this document at the outset, and therefore that has prejudiced your case for your defense, which is why you lost. So we're not going to cover you. Do not allow that situation to arise. And of course, full cooperation is needed all the time, and meeting the lawyer. Even if there's a potential claim, especially if there's a notice of demand, you must actually meet the lawyer to explain what's going on, because the lawyer needs to then report back to the insurer as well. You should also prepare a chronology which you would have given, I think, by then to the insurer. Get all your documents, even if you think it's not relevant, but get all the documents that is involved or that exists in that project. Don't say, our contract is this thick. I'm not going to bring it along. But you need to, right? You don't have a choice. And you must actually set aside some time for that, because you want to try to deal with it as early as possible so that there is a chance that you may arrest the situation there so that it doesn't escalate. If you give all the documents and perhaps a proper reply is given to the notice of demand, it may stop there. And even if it does not, it's going to help the lawyer and yourself with preparing for the case and the defense. Because there are many stages. touch wood, hopefully none of you have to go through this. But from the notice of demand, it's going to be, if it goes on to court, it's going to be again a tedious and prolonged affair. It's not going to be, 1 week later, he filed that. What happened? Nothing happened. Still in court. It'll go on for months. And if it goes to appeal, it may even go on for years. So you will have to actually get mentally prepared. You have to accept that it's going to take time. You also must accept that you will have to spend time in preparing for the case and the defense and instructing your lawyers. Instructing means whatever they need, you have to provide. Otherwise, it may prejudice the defense on how you fight the case. So next, let's go to the non-delegable duties and torts. We will have a look at this case, Management Corporation Strata Title Plan, against Tiong Ek Construction Private Limited and another private limited. So you will know that it's a Singapore case in 2016. Coming back to non-delegable, as I mentioned earlier, usually as an employer, you are an employer because you appoint your subcontractor or subcontractor, NSC, whoever it is, to do whatever work that you want them to do. And that's it. You are not liable for that contractor's negligence. Right? If he's negligent in whatever he does, he's careless or leaves a hole, someone falls in it, whatever it is, you're not, because that is the general law when it comes to independent contractors. Not only when it comes to architects and subcontractors, but we all hire independent contractors every now and then in our lives to come and do our painting job, whatever it is. Everybody uses it. So independent contractor is liable unless he's your employee, then it's different. But as far as non-delegable duty is concerned, it's an exception. It's where an employer of an independent contractor is liable. It's okay. Is liable for the wrongdoing and the negligence of whoever you hire. It doesn't matter whether it's independent contractor. So it's an exception. So the meaning, really, if we can put it in a nutshell, of a non-delegable duty is the conventional way of describing those cases. Ordinary principle is displayed. And the duty extends beyond being careful yourself to procuring the careful performance of work delegated to others. Right? So non-delegable duties are characterized as arising from assumption of responsibility imputed to the defendant by virtue of his special relationship with the claimant. We'll come to that. However, non-delegable duties represent a markedly more onerous obligation than just a positive duty. The defendant is taken to have assumed, and here is the architect, assume responsibility for the exercise of due care by anyone to whom performance is delegated. It's an exception. It's an exception. Various rules apply here, various laws. Although some of the jurisdictions, for example, England and Australia, have said that it is not an exception. This rule has been around for a very long time. And there are reasons why this rule applies, non-delegable duty. And it doesn't apply. I keep saying it doesn't apply in every situation, right? For it to bite, to make the architect liable, there are certain things that the plaintiff needs to satisfy, or the situation should warrant such an imposition of such a duty. So it's not a departure from basic principle. As I said earlier, not really. It is not a departure from our basic principle. The basic principle is there, and this applies when certain criteria exist, certain situation exists. In Malaysia, the federal court answered this in the case of Dr. Kok Chung Seng against Su Cheng Lin, another, by saying that non-delegable duty exists in Malaysia, and it has, for example, here, we consider character of non-delegable as a departure from basic principle to be misconceived, as I said. The law of negligence is no stranger to the concept of positive duty to protect another from harm. A positive duty to guard against harm caused by a third party may arise from special relationship between the plaintiff and the defendant, giving rise to an assumption of responsibility by the defendant. So the nature of a non-delegable duty is, in essence, a positive duty to ensure that reasonable care is taken. The case that I cited earlier, that we saw earlier, and after that, there have been various other cases involving hospitals. So for a long time, hospitals in Malaysia have got away with covering the negligence of a doctor in also vicarious liability, because doctors are not the employees. If you go to a hospital, not talking about government hospital, our private specialist hospitals, all the doctors that you see in the various clinics are almost always an independent contractor. They are not an employee of the hospital. So under employment scenario, there is no some independent contractor. He pays rent for his clinic. He pays various charges to the hospital, and they share their fees or whatever it is. But in the case that I cited earlier and a later case called Hari Krishnan, the hospital was found to be liable for the negligence of the doctors, there were few specialists involved, not on the basis of vicarious liability, but under non-delegable duty. There are certain things that the hospital cannot delegate to anyone, including the specialists. The hospital must take responsibility. The other issue in one of the cases was that the choice of the specialists. If you go, I mean, most of you would have been to a private hospital. If you go there, they'll always ask you, who do you want to see? And you will say, for orthopedic, I will want Mr. A, Mr. For another, they'll always ask you, who do you want? Even the person who gives you the gas, they'll ask you, which one do you want? So in those scenarios, the hospital may not be liable because you made the choice. But in some of these cases, the hospital became liable, amongst other reasons, because the hospital chose the specialist for you. So when they choose a specialist or a doctor, then they must assume responsibility. It is also because certain areas attract non-delegable duty. One of them is where hospitals and patients are concerned, because it concerns safety, it concerns life of a patient. Right. Certain areas you can't delegate the duty. So I hope you're getting the drift by now. So as I mentioned, examples where non-delegable duties have been held to exist. Employer's duty to take reasonable care for his employees' safety. This is not your employees' negligence. It is you must ensure that they have a safe system of work, safe place to work. Right? If your area is not safe enough and they get injured, you cannot delegate the duty just because I've got an independent contractor. He's the one who came and repaired the floor. You can't do that because it's a question of safety. It's a question of relationship, that special relationship between employer and employee. Number two, as I mentioned earlier, hospitals and health authorities as regards their duties to their patients when it comes to their safety and so on. The other area is schools and school authorities as regards their duties to their students. They can't delegate. For example, one of the cases where non-delegable duties came into play is where the school actually employed a swimming coach or a swimming company to come and train the students in the school. It's an English case, if I'm not mistaken. And something went wrong. The school said, look, it's not my fault. I've got an independent contractor, it's outsourced. Say no. When you're a school and it concerns your students, you are responsible. You can't delegate the duty. The other area is non-delegable duties may be involved in cases of extra hazardous operations. And this is where it becomes relevant to architects in this context. So when there's extra hazardous operations involved, you can't delegate your duty. The other case that I'm going to just touch on will make it clear. For example, it's quite similar, but not the same as strict liability. One area of strict liability is, for example, even local authorities, when they carry out works above roads and highways, it becomes strict liability. If anything happens wrong, anything goes wrong there, they can't say, but no. You carried out work above the highway and road. If anything happens to the road users, it's called strict liability. Similar to that, when safety is involved, hazardous operations are involved, architects cannot delegate their duty. Okay, so these four areas are the general areas that exist when it comes to non-delegable duty. It does not mean that new areas will not be opened or be recognized by the courts in the future. It does not mean that. Just like categories of thought are never closed. Having said that, I must hasten to add that it is not very easy for the plaintiff to argue that, you're an architect, non-delegable duty must apply. No, the courts will first look at those categories, and the courts will look at whether there is also a close proximity, whether special relationship exists, whether you have control or care of the person that is suing you. That's a Woodland principle. But let's go on to the next page, where I want to just go on to this case, that Singapore case that I mentioned. The central issue for determination of the Court of Appeal of Singapore was whether and to what extent the management corporation had recourse in tort against the builder and the architect for building defects in the common property or the condominium development, where the defects were not caused by the negligence of the builder and or architect, but by the negligence of the subcontractors. This is a Court of Appeal matter. In the High Court had dismissed the claim brought by the plaintiff against the builder, the architect, and the subcontractor and the developer. But they only appealed against the builder and the architect, attempting to apply the principles of non-delegable duty. So, next slide. So here, the key contention advanced by the appellant, which is the claim was brought by the management corporation of that development, the Seaview development, right? Here, the key contention advanced by the appellant was that the builder and the architect were subject to a non-delegable duty in tort to ensure that the building and design of the Seaview condominium was carried out without negligence on the part of any of the subcontractors. But I'm sure by now you would have already formed an opinion, and the question would be, this is the case, every architect will be liable. Right? I mean, that's my view when I first read my first round of reading of this case. Every architect or the builder, every single person who undertakes any work will be liable. And you will fortify your opinion or your view when we just look at brief facts of this case as to what they did or what the subcontractors did, right? So we go to the brief facts. Here, as I said, the management corporation was a management corporation of that development called the Seaview. The Seaview was completed with 622-story residential blocks of apartment comprising 546 residential units. The respondents were Tiong Ek Construction, the builder. That's one of the respondents. The builder, who was the main contractor. And RSP Architects were the architects of the Seaview project. So only two were brought up to the Court of Appeal. The management corporation sued the developer, the main contractor, the architect, and one of the architects, subcon, in respect of defects in the common areas. However, it cited only the main con and the architect as the respondents to the appeal, leaving out the developer and the architect's subcontractor. So the defects, so this is where, as architects, will be surprised as to why the corporation is bringing this action against the architect especially. Defects complained were as follows. The fiber optic cable issue concern alleged incomplete or inconsistent fiber installed by Singtel. And any negligence relating to the installation of the cables would not lie with how the defendants had performed their contracted work, save for the main contractor's possible lack of care over his control for the construction site. So the fiber optics was actually installed by Singtel. Number two, the poolside landscaping issue concerned the alleged negligent design of the trees and plants around the pool, which led to the nuisance of small leaves falling into the pool. Right? This was designed by Site Tectonic, who would be what? Who would prima facie be liable for its own negligence. Number three, the foul smell issue concerned bad odors in the kitchen and wash areas and adjoining bathrooms. Some bedrooms in various apartment units. This stemmed from an alleged defect in the design of the plumbing and sanitary system within the scope of Squire Mac Private Limited. They were the subcontractors. So Site Tectonic and Squire Mac were independent contractors of the architect. So this was the alleged defects. So without going further, you again say that how can this be non-delegable duty? Right? But I must pause to add here or to note that the management corporation who were the plaintiffs, appellant in the Court of Appeal, had other limitations with other parties. Their case against the other parties were not that straightforward because of various technical issues. And of course, the main con and the architect had the deepest pockets. The subcontractor, apart from Singtel, I think, they were not very wealthy, so to speak. So they had their reasons why they wanted to pursue against the builder and the architect. So here, the management corporation claimed against the architect in tort for failing to employ reasonable care and skill in the design of the development and or supervision of the works. The MC did not argue that its proposed non-delegable duty against the architect fell within the four existing established category of non-delegable duties, which I pointed out earlier, right? The four established. Its argument was that the creation of a new category of non-delegable duties for construction professionals was justifiable and desirable on both legal principles and general policy grounds. Under the law, of course, you have the law, you have legal principles, and you have certain policy considerations that applies. For example, the courts in this country do not recognize illegal agreement tracts. If you contracted with someone, even in writing, to actually supply 1 kilogram of heroin to somebody else, and later on you don't pay him, he can't sue you on that. It's an illegal contract plus its policy consideration. There are certain countries or jurisdictions have policy considerations which is sensitive to that particular country. Those are policy considerations. The explanation is that it's in the national interest or some other interest, not necessarily strictly legal. So they were saying that it was justifiable and desirable both on legal principles and general policy grounds. Legal principles, since they couldn't bring it under the four established categories, they wanted the courts to expand those categories. The courts agreed the categories are never closed. But the courts actually did not agree that these situations warrant extending the non-delegable duty categories. The other argument that the appellant was canvassing was that there was a special building bylaws in Singapore that makes it mandatory for all architects and engineers to follow when it comes to safety of the building. So if the design involves safety of the building, then you don't even have to go into the common law tort of non-delegable duty. The rules or the law was already there. So what the appellant was trying to argue was that since this law is already there, the courts then must expand the categories of non-delegable duties to make the architect liable. But the court said no, that regulation or the law is specific to safety of the building, of the project. So that was thrown out. As far as policy consideration is concerned, they were arguing that because they had the technical problems against the other parties, as I mentioned earlier, that it should be easier for management corporations and purchasers to sue one or two parties so that they don't have to go through so many processes and procedures. Why do I have to sue the subcontractor? Why do I have to sue? Let me sue the architect and the main con and be done with it. So of course that argument was not very strong and it was thrown out. So both you'd be glad to know, of course, the architect was not liable there. But the court, on the Woodlands principle, whether there was sufficient proximity, the court found that there was a degree of proximity and assumption of responsibility in the relationship between the MC and the architect. The question which therefore remained was whether the degree of proximity and assumption of responsibility, although sufficient for establishing an ordinary tortious duty of care, was sufficient for establishing a non-delegable duty of care. The court noted that a number of key features identified in Woodland were not present in the relationship between the management corporation and the architect for a non-delegable duty of care to arise. The principles stated in the Woodland case is close proximity, and some of the other things that I mentioned, you must have care or control over the plaintiff and so on. So the development of new categories should proceed only on the basis of a clear analogy to a recognized class, and then only for compelling reasons of legal principles and policy. And you'll be glad to note this is what the court observed, and this is where it stands even in Malaysia, right? And accordingly, of course, the management corporation's argument on the creation of new category failed, and the claim against the builder and the architect was dismissed. Now let's look at the Malaysian position. So it's not an easy thing for a management corporation or any party to do by bringing in the architect, a non-delegable duty where the subcontractors or independent contractors, but it is there, right? It is not something that which is plucked out of thin air. It's not. It's there. So when it comes to, I just want to reiterate, when it comes to hazardous work or involving safety and so on, the non-delegable duty will apply to any profession. So here, the concept of this non-delegable duties has been applied by the Malaysian courts in construction context as early as 1993 under the category or circumstances of extra hazardous operations. And in the case of DBKL against Ong Kok Peng, you may have come across this case. This is what happened. So sometime in 1980, the claimant wanted to collect some keys from a friend who was living in a unit in the cleaning flats owned by DBKL. So the owner is DBKL. He then suffered severe injuries as a result of falling into a lift shaft in the flats as he was stepping into the lift. On seeing the lift door was open, there was nothing there. There was no warning sign or barricade of any sort placed at the lift door to indicate that the lift was not in service. The maintenance of the lifts were covered by a maintenance agreement between DBKL and a third-party independent contractor. So here again, DBKL said that, look, the lift and the maintenance has been contracted out. I even have an agreement. It's an independent contractor. The lift was under service, repair, and maintenance. The door was left open not by us. It's by the independent contractor who's doing the maintenance work. So how can you hold us liable? But the courts found in favor of the plaintiff who fell into the lift shaft, and DBKL appealed against the decision. So here on appeal, the Supreme Court dismissed DBKL's appeal insofar as the finding of liability against it is concerned, and held the respondent fell through a lift door which was partly open, and there was no warning of any kind about the danger as the lift was out of order, and neither was there any barricade of any kind. This was created by such an extra hazardous act or omission involving special danger to users of that lift that the appellant could not escape liability for the injuries caused to the respondent. Further, not only because of number 3, is only further, the maintenance of the lift was a statutory duty imposed on the appellant by the Factory and Machinery Act 1967, and DBKL could not, it's okay, escape liability by delegating it to the third party. I delegated it to the third party here. I should have known that this extra hazardous word, right? I'm still liable. So that's what happened in this case. And I think, I mean, yeah, the next page. A non-delegable duty to take care means, in effect, that the employer would have to see to it that such duty of care is exercised whether by his contractor or not. Otherwise, he would be equally liable as the contractor. So I think you would agree with me here that the Supreme Court got it right, because it is extra hazardous work. And you can't just leave it to an independent contractor. You must supervise. You must then maybe, do rounds, make sure, I do not know how else you supervise in your architectural perspective. Perhaps, get them to give you a report every half a day, or ensure that barricades are put up. I mean, that's quite an easy solution to do, right? Ensure the barricades are put up and so on. So that's non-delegable duty. I'm sure in your work as an architect, you will come across situations where safety is involved, where your design may involve extra hazardous work. I'm not sure between architect and engineer, for example, slope protection, treatment of certain structures, it may call for non-delegable duty to be looked at, because the works involving safety, extra hazardous, you would know, in your day-to-day operations. So that's as far as non-delegable duty. So you may want to bear that in mind. I'm sure a lot of you here know that already. So now let's move on, coming to an end. How to actually mitigate or minimize whatever that is going to arise. So know your contract very well. Right? What is required of you in your contract? Of course, a lot of us just sign our own contracts blindly. Lawyers are the biggest culprits. When it comes to our own documents, we just sign it. Hire purchase loan, I don't even know what it says. So we just want to know when is the last payment. But I am told, and I've through experience, I know architects actually read all the fine prints. No. Policy wording more so policy wording, I think, right? So you need to know what covers you. So read your contract, be familiar with the statute, especially when you younger ones, they start off. Know what your responsibilities, what you're supposed to do, contract management, what is required of you. A lot of you here are very experienced, so this is actually elementary. You may also want to try to impose limitation of liability clauses in your contract, or you may want to seek indemnity from your subcontractor. You may want to look at things like that. So maybe for more contracts, bigger contracts, I don't know how to label it. All contracts are important, especially contracts involving safety contracts or work, extra hazardous. Want to then want to exercise more caution, maybe even consult a lawyer or other that are perceive what happened and so on. That will make your insurers happy as well, I suppose. Then they don't have to cover, then you don't do any wrong. Right? So that's basically what I have to say, except to mention on the Limitation Act, which was mentioned by Ms. Shamini. Of course, general limitation for negligence and so on used to be just 6 years. And now they've amended the Limitation Act to the date of discovering especially in latent defect. So even a person discovers after 10 years, is 3 years from that discovery. Because there's a general limit to 15 years in total. If anything happens after 15 years, then limitation kicks in and a plaintiff can't make a claim. So you may also want to be aware of that. So for that, I think I'm not here for the insurance policy, but that would give peace of mind when you retire and so on, because it's not just 6 years, it's longer. We don't have that cover for lawyers. That's not fair. We don't have the retirement cover because lawyers apparently don't retire. They just lose their appeal, right? So that's probably why. It's no. Retirement cover. I don't read my policy. I was just trying to do a marketing talk for you. It's not that I pointed that out. But, yeah. Yes. I will not. I will take that up later. Okay. Well, question and answers. I'm sure you have question and answers. There are a couple of questions there. If it, okay, is that about the policy or is that about?
It's actually about the fee, and I think it involves the policy as well as a legal position. So I'll read the question first. To avoid the technicality of pro bono, because we said pro bono work is not covered. If, say, you still charge a token fee, but not as per the prescribed fee under the architect's scale of minimum fee, will you still be covered under the policy? Because principally, it's no longer pro bono. So I read the question. Shamini, would you like to take the answer?
Yeah, I mean, first of all, I think it's for the insurers to answer that question.
Yes.
Because the legality of the fees is a different issue. If I may just draw an analogy to the legal practice,
Yes.
we know that conveyancers do give discounts, although it's not allowed under our solicitor's remuneration order. But if a conveyancer is sued for negligence in the work that they do, this has never been called into question so far.
Correct.
You very
Yep.
familiar with that.
It's not being called into question. So Minnie, would you like to take this?
On the similar basis, insurers will not really look into what you do in terms of whether, hello? It's working, right? Hello? Yeah. Why?
Is it? Yeah. Just try again.
Hello? Oh, it's not.
It's not because it booms. Like.
Hello? Hello?
Hold on.
Hello? Hello?
Are there?
So basically, taking from what Dato' already said about how it works for conveyancing in the legal profession. Actually, this question was posed previously by some of the architects, and I actually did speak to the insurers about this. As far as the insurers are concerned, their position is they're not here to police the profession. You know, if it's a dispute of the fee issue and whether you overcharge, undercharge, that really does not go into they will not decline cover on that basis. That is between you and your client, your regulator, and all that. But if a claim were to come in, but in that particular situation you had given a discount, insurers will still provide you cover. Hope that answers. Yeah, that's. Are you? Agita?
There are no exceptions. Then charging the $1 or the $1 is your way of getting around it. So the question comes up then, right? But they're not going to, how shall I say it? Pro bono is not. I feel to hear this sound is something's happened. Yeah.
But that's not been an issue. Yeah. Yeah, so I can't comment further than that, it's fine.
A breach of the law.
Will lembaga
Yeah.
yeah.
Or something, and then he sues you. Then if it's in tort, like what Dato said, there is a duty of care. But what is he suing you for? So there's no straight answer to this pro bono question, right? So you just have to, if you're following your regulations, just follow your regulations. Okay, the next question I think is for an architect answer. It's also from Amirval Kosa, and it's a follow-up to the first question. And since we are discussing fee, must all the fee be in accordance with the minimum fee scale, or are you disqualified for any reason if the fee is deemed discounted? Would an architect like to take this question? You don't know the answer, or you know? Because normally when we're in KL, we get one of the office bearers to take this question.
Extend what you mentioned earlier. It's a question between a member and the regulatory body. For example, just like the legal profession, and I'm sure the architect profession as well, it does not extend beyond LAM and the architects. You cannot be prosecuted, an architect cannot be prosecuted in a court of law for not following that scale. So that there is no breach of law in that sense.
It's a disciplinary thing, right?
Yes.
Yeah.
Yes.
His question now is, would he, I think if I read into his question, would he be disqualified if he gives a discount? I think Amirpal Kosa, this question has to go to LAM. Okay, and next question is Shamini. What if the appointment of the architect is the lead consultant? It's a long question, be patient. And where all the other consultants are under his appointment, does it mean he's required to take an additional policy as per project basis in such circumstance? The other consultants may have only minor role as per the overall scope. Is this reviewed on a case-to-case, but in reference to the fact that the architect has already taken a policy to cover all his projects? So I think we are going to break this question up in parts. So we'll start with the first part. What if the appointment of the architect is the lead consultant and where all other consultants are under his appointment? Does it mean he's required to take an additional policy?
Okay, no. So there's two. The first thing is you're the lead consultant and you've got all the sub-consultants. Your policy covers you, the architect. If it doesn't cover your sub-consultants, but let's just say you and sub-consultant, architect, sub-consultant are named in a suit, for example, right? And you are, it may be the sub-consultant doing the work, but you are also dragged in as the lead consultant. If the court finds that as the architect, for example, non-delegable duty, you are still responsible, whatever that is payable or whatever liability owed by you as imposed by the court will be covered. But if anything that has to be paid by the sub-consultant, no. They only covered you, right? Sub-consultants in that case should have their own policies.
So the only exception, would it be, I'm going to ask you questions because I need to clarify his questions. So is the exception where he's required to take a single project policy then? Because his single project policy, is it safer for him to take that and cover all his sub-consultants?
Yes. Okay. So if you want to cover the works of your sub-consultants, as I mentioned earlier, that's where you get a single project policy. But note difference. So when you buy an ARcover policy, it's an annual policy that you renew every year that covers everything that the particular firm does. When you buy a single project policy, what it means is architect, lead consultant, your sub-consultants, everybody shares one policy. And it will start from whichever date you like it to start for whatever period that you like it to start. So in that situation, the one insurer will cover anyone's mistakes. So it doesn't matter whether it's lead consultant made a mistake, sub-consultant made a mistake, whoever did it, the same one policy will protect everybody. So there's benefits to that. So you don't have different insurers, different blame game going on. So that you are all protected under one policy for this particular project.
We do encourage architects to buy annual PR. As opposed to an ARcover single project policy, it is safer for your practice to buy an annual PR because you just renew it every year, it covers all your work. But if your client has set specific condition in the appointment, you need a single project PR, then yes, you're going to cover all your consultants, get them to contribute. That's what other architects do, isn't it? They get the other consultants to contribute a share.
Basically, if the premium is based on how much the breakdown, what percentage of the fees, and that's how they divide it among themselves. And just one more point to add on, if you have a single project PI, it's usually, for example, for a bigger project or there's many parties involved. So let's just say you buy 2 million for that particular project, and in the event that policy is not enough, for your firm, your annual PI can work as an addition to it. But only for you, your addition is only for you.
Just going back to, I think, Dato just now on the case that I think if the court judgment at the end of the day says that the consultant or the architect is what you call liable or is wrong, or no, I say liable. I wouldn't use the word dishonest. There's loaded. So that the insurance doesn't cover us in that sense. Is that true?
No. Hence, I think why Dato asked the question. When you say liable, means liable for negligence.
The judgment, yeah.
The judgment says you're liable for negligence.
Yes.
You had wrong drawing, your measurement, something wrong, liable for negligence. That's the entire purpose of your ARcover. Only if it's found that you were dishonest, you lied, you tried to take undercover, you tried to cut corners, fraudulent, then it's not covered.
Fraudulent, you're not covered by ignorant.
Yeah, hence, if you were innocent, you're covered.
But,
Yeah.
yeah. Because otherwise we defeat the whole purpose of us buying.
Because, I mean, your clients will allege everything. Most of the time, they'll probably throw the kitchen sink at you and say, you lied, you misrepresented, whatever. I mean, at that stage, it's fine. If you were not acting dishonestly, that's exactly why you.
Yeah, I mean, obviously we know that, but I mean, ignorance and especially nowadays for consultant or even building construction claims and things like that, the word duty of care sort of loom heavily above us, and also proximity. I think often for example, we have gone through street battles for a lot of years, so we know what it's like, right?
So that's, as Shamini pointed out, that's precisely what the policy is supposed to do. I think what Shamini was talking about earlier is where it comes to dishonesty, which is a rare thing. It's not a normal thing. Her point that she was trying to make was that even if your partner is dishonest, you will still be covered. Because if the firm is found liable, even if the partner is dishonest, the other partners will still be covered. That's the point. Over and above, gross negligence, non-delegable duty, all that is covered by them. All that is covered. Even if the court finds you liable, what I was talking about earlier, if the court finds the architect dishonest, then they may change their coverage.
It's for you, Dato. Does it cover willful negligence? Yes.
A question for Tato. Just now, I think the first question mentioned about a group consultancy. That means the client award to the architect, and under the architect, there are various consultancies. In your opinion, for the architect's perspective, what do you think? I mean, is it good or bad for the architect, or this kind of contract? Is it? I think it's bad. We don't hear.
As a group, I mean, there's got nothing to do with insurance, I think. I can't say good or bad, because sometimes you need to get other consultants. You may not have all the consultants within the same firm. Yeah. Right. I mean, it's better. Yes, it's your response. Legal responsibility, of course, is not good. Then you take responsibility as far as the principal is concerned for all your subs, so to speak, because then you are liable for that. Yes, because lead consultant is the submitting consultant. Unless they are submitting different, unless they are, yes. Right. So, but in a lot of projects, is the engineer who is a submitting consultant. Yes, but it depends on which part of the negligence is questioned. Right. Yes. So you'll be liable to the principal for negligence, but regulation is different. Who's submitting is different. So of course, in an ideal situation, it's better for the principal then, upon your recommendation or your suggestion, he appoints everyone. Then your liability is only towards one angle, only towards the principal and one angle. Otherwise, you're assuming, and that's what the principal wants to do. As far as the principal is concerned, I just deal with you now. What happens, I don't care. I mean, it's a question of, I don't know, sometimes that principal architect may be able to command a higher fee because he is only principally liable. The employer doesn't have to look at everybody else. Whereas if you went to each individual, then the fee structure may be different. Yeah, talking about what happens to the ground.
Extend on this question. Let's say I'm the client comes to me, and then he also goes on to hire his own engineers and QS and whatever. I say, I want to partly under you, although the consultant said, I'm not your choice. The responsibility as the lead consultant similar?
It depends on what is the label park. Is he saying that you are then liable for everyone in the legal sense, or you work together? So if you work together, they are not part of you. So it depends on what kind of agreement they come up. Yes. So in that situation is where I mentioned earlier, if possible, if they want to have exclusion clauses, you may want to actually spell out the scope of works in detail. You may want to have indemnity from the other chaps as well. You want to get the other chaps to be insured as well, so that their indemnity is not empty. Sometimes you can get all the indemnity in the world, but if the claim is big and if that particular person has got no money, then you can't do anything about it because you're principally liable, which is where then insurance comes in.
There is the nowadays in our practice, yeah, so-called the Form Gs, where the engineers sign for works which is related to them, verify that this satisfaction done and things like that. So actually, the Form G was designed to portion and delegate the what they call responsibility in a way with various consultants. So if like just now, Bob Chong was mentioning if that sort of the defects that happens in that project is due to engineers and not the architects. So does that mean that with the Form Gs that comes in, we will force the what they call responsibility to the engineers?
To a large extent or to an extent, but it again depends on your agreement that you have with the principal. If the principal says that that's between you and the engineer, then what the principal will do is he'll hold the lead consultant responsible, but you then have a valid claim against the engineer as a third party or indemnity. So it doesn't, if the principal takes an action against the architect, it doesn't mean that the architect cannot also go down the line and take action. Yes, that usually happens by making them either third party or under the indemnity that you have, that you seek contribution and indemnity. But the problem with bringing in someone as a third party, sometimes you can bring them in as a co-defendant, is that you are principally liable. Then if the court grants an order that you have a claim against a third party, you have to pay to the principal first, and then you have to seek payment against the third party. So it is not directly between the principal and the third party. Yes, co-defendant, then the court will make a finding as to who's wrong. The court will say, yeah, defendant 2 is liable, therefore defendant 2 is going to pay.
Any other questions? Yes. Yes, I think it's for the benefit.
Just to elaborate from just now as a lead consultant that engage with other separate profession like engineers or maybe QS. I thought the doctor said the scope of works, if in the engagement we specified that if anything happens towards their related to the profession, is the lead consultant has no responsibility to take any liability. Can we state that in the agreement or contract?
You can. It really depends on whether the principal, the employer, is going to agree to that. Because that's more what actually happens on the ground. Because the reason, I'm just guessing, the reason why the principal wants to hire a lead consultant is because he wants all the responsibility to be on the lead consultant. What happens behind that line, he does not want to know. So if you separate or if you break up the responsibility too much, the principal may say, no, in that case, I'll go and deal directly with the other consultants. It depends on the situation and the circumstance. But it's prudent to ask for that to be included in the contract. If the principal agrees, then that's good.
So what you mean, like for this engagement, mostly employee interested to let, to develop
If that's his intention, because he wants to keep it simple, then he will not agree to breaking up the responsibility and who's liable and who's not. it becomes too, I mean, yeah, you just want to be always actually basic of the great stuff that I want to then you know, I mean, that's a case to case basis. It depends on how the employer is involved. You can getting around putting it clearly so that the employer doesn't know what's going on. Actually, duty is not duty is a duty that's not duty.
Okay, can I add something here? We do quite a lot of jobs with government and private, where the lead consultant is quite the norm now. So the issue here that you want to elaborate is that there are two parts. One is a contractual, and the other is professional. Okay, even though the consultants are lead consultant architect, but the professional liability in terms of submitting persons and CCC are still under the individual engineers. Okay, that's why the Form Gs are there in the first place. Even if there's no Form G, they are still the submitting person under their own board of engineers, right? So there are two. One is we are signing a consultancy services agreement with the whatever ministry or even private developers. That's a contractual. They appoint us architect and they appoint the other consultants, i.e. engineers. That's a contractual duty of care for us to the owner. But in terms of professional design wise, if there's a case, the engineer is still liable. Is that there are two separate matters here? Okay.
Is what how he becomes liable, the steps or the procedures, what I was addressing earlier. So if contractually whatever happens, if contractually you surrender everything to your employer, then the employer look at you first. But of course, that doesn't mean that you can't go down the line. And as far as the authorities are concerned, this is just apart from what we're talking, as far as the authorities are concerned, the authorities are not really concerned with what contract you have with any party. The authorities will look at Form G, for example, submitting architect or submitting engineer, who is signing them. So that's as far as the authority is concerned. So contractually and, like you said, professional duty and liability is separate. But legal procedure as to what actually happens may be leaning towards more contractually when the employer is looking to hold somebody liable. Yeah, that's what they want to do. That's what they want to appoint you as a lead.
I guess any other questions? No, I'm just thinking fashions of Kerala, but anyway.
I mean, ARcover is about a year old, right? So we didn't actually experience this when we first when this scheme was first launched with PAM. But this year we have noticed there are a number of firms who want to purchase professional indemnity when there's a realization of a potential claim. So we'd just like to make it clear because we don't want to have a misunderstanding later. You know, like when you did the presentation, you said there's full retroactive, there's this, there's that. Please remember, it does exclude anything you know or you are aware of. That's all. That's the closing. No, I think that.
Okay. Yes. At walking distance, architect. But- Oh, okay. Thank you very much for your time. Thank you, Dato. Thank you, Pam, Northern Chapter, for having us. Now I'll pass it on